Welcome back to the Sussex Unfiltered. Today we're diving into the latest development in Prince Harry's High Court battle against the Daily Mail publisher. When the headlines dropped about this recent ruling, my inbox exploded. People were asking, is this bad for Harry? Did he lose? Should we be worried? Here's the truth. This ruling narrows the scope of Harry's case, but when you understand what actually happened, you'll see this could work in his favour. Let me explain exactly how. So, grab your coffee and let's unpack this together. Let's make sure everyone understands what this case is really about, because it goes much deeper than tabloid drama. Harry, along with 6 other public figures, Elton John, Elizabeth Hurley, Sadie Frost, Baroness Doreen Lawrence, and others, is suing Associated Newspapers, the publisher behind the Daily Mail. This isn't a typical defamation case. The plaintiffs are asserting that the publisher engaged in systematic, unlawful information gathering. We're talking about hiring private investigators, intercepting voicemail messages, using blagging, which is lying to obtain private records like medical files and bank statements, and other invasive tactics to dig up dirt on people's private lives. Think about that. Not just reporting on public information, but actively breaking the law to invade someone's privacy. For Harry, this is deeply personal. He's connected this predatory tabloid behaviour to his mother's death and watched his wife be torn apart by tabloid coverage. He's determined to hold these institutions accountable, not just for himself, but for everyone who's been victimised. The stakes are enormous. The trial starts January 14th, 2026, and will last 9 weeks. If the claimants win, it could fundamentally change how tabloids operate in the UK and open the floodgates for other victims to come forward. But if they lose, it sends a message that powerful institutions can continue these practices with impunity. That public figures have limited recourse when their privacy is violated. So this isn't about one prince's grudge. It's about whether we allow journalism to be weaponized through illegal means. On October 10, 2025, Mr. Justice Nicklin issued a ruling that narrowed what evidence Harry and the other claimants can use at trial. Here's what changed. First, no generic or propensity evidence. In plain English, Harry's team can't say Associated Newspapers has a culture of doing shady things, therefore they probably did it to us too. The judge is requiring specificity. Each claimant must tie specific alleged misconduct to specific journalists or private investigators who worked on their particular cases. So instead of saying the Daily Mail routinely hacks phones, Harry has to say, this particular journalist working on this story about me hired this private investigator who intercepted my voicemails on these specific dates. That's a much higher bar. Second, some claims got struck out entirely. The judge rejected a 1992 allegation about Mail on Sunday journalists, calling it too remote, more than 30 years old, and not relevant to current claims. An attempt to accuse Associated Newspapers of destroying payment records was also dropped for being speculative without evidence. Third, stricter burden on linking evidence to individuals. This is the heart of the ruling. Claimants must show clear, documented links between misconduct and named individuals. No circumstantial evidence or patterns. They need the smoking gun. For the defence, this is obviously good news. But here's where it gets interesting. I know it sounds counterintuitive, but this refinement could actually help Harry. Here's why. 1. Sharper focus creates stronger arguments. When you can present everything, your case gets diluted. You're jumping between allegations without drilling down on your best evidence. By forcing Harry's team To focus on specific allegations with named individuals, they zero in on what they can prove beyond reasonable doubt. That makes the case more compelling and harder to dismiss. 2. Fewer weak points to attack. Vague allegations are easy for defense attorneys to dismiss. Where's the proof? This is conspiracy theorizing. By keeping only claims with strong evidence, Harry eliminates the weakest parts of his case. 5 rock-solid allegations are stronger than 20 allegations where 15 are shaky. 3. Avoiding fishing expedition criticism. The tabloids portray Harry as being on a vendetta, attacking journalism itself. When you present broad institutional claims, that narrative gains traction. But when the case focuses on specific incidents, specific people, specific dates with evidence, that criticism falls apart. It's harder to call Harry unreasonable when he's documenting specific illegal acts. 4. This still sets crucial precedent. Even with constraints, winning on specific claims establishes that tabloids cannot use illegal methods to gather information. It raises the bar for media operations and creates deterrent effects. A focused, winnable case that establishes important precedent beats a sprawling case that risks losing on technical grounds. 5. This is standard legal strategy. Experienced litigators often prefer narrower cases. Juries and judges can only process so much. 5 bulletproof examples with clear documentation create a memorable story that leads to favourable judgments. While the media spins this as a setback, Harry's legal team might actually be relieved to build a tighter narrative. Let's be clear-eyed about the significant hurdles that remain. Challenge 1. Proving specific links. It's one thing to know you were surveilled. It's another to prove it in court with documentation tying it to specific individuals at associated newspapers. The defense will demand receipts, payment records, communications, phone logs. Without direct evidence, claims fall apart. This is especially difficult for activities from years ago when memories fade and records disappear. Challenge 2. Surviving cross-examination. Harry will likely testify, and defense attorneys will come at him hard. They'll pick apart every public statement, looking for inconsistencies between his memoir, interviews, and court testimony. They'll portray him as someone with an axe to grind, trying to make him look emotional or unreliable. Every witness faces this scrutiny, and any weak link could undermine the case. Challenge 3. Financial constraints. Judges capped legal costs at around $4 million per side because both parties had budgeted astronomical sums. For a 9-week trial with expert witnesses, document review, and top-tier representation, that money disappears fast. Harry's team must make tough choices about resource allocation. Even if Harry wins but spends more on legal fees than he recovers, it's a Pyrrhic victory financially. Challenge 4. The Court of Public Opinion. Associated Newspapers has a massive platform to shape public narrative. Every day they can publish articles portraying Harry as litigious or attacking press freedom. While public opinion doesn't technically matter in court, it affects whether witnesses come forward and whether Harry can claim any moral victory. His team needs a communication strategy running parallel to the legal strategy. For those following this case closely, here's how to approach the next 14 months until trial. First, frame this as refinement, not defeat. When people ask, explain that tighter evidence standards make the case more credible and likely to succeed on claims that matter most. Second, keep focus on the actual stakes. This is about whether powerful institutions can break the law with impunity and whether privacy means anything in the digital age. These issues affect all of us, not just celebrities. Third, stay evidence-focused. Resist making unsupported claims. The other side wants Harry's supporters to overreach so they can debunk accusations and discredit the movement. Stick to what can be proven. Fourth, follow the money and patterns. Watch for financial records, payment patterns, and timing between payments and published stories. These patterns can be damaging even without proving every transaction was illegal. Fifth, prepare for a marathon. The trial starts January 2026 and lasts 9 weeks minimum. There will be good and bad days for both sides. Don't let one adverse ruling shake confidence in the overall case. I'm not telling you this case is a slam dunk for Harry. It's not. It's going to be hard-fought, expensive, emotionally draining, and uncertain. But what I will tell you is this. The October 10th ruling, while narrowing the battlefield, also clarifies it. It forces both sides to put their best evidence forward. And if Harry's team can prove even a fraction of what they're alleging, this could be a landmark moment in media accountability. We'll be here every step of the way, breaking down filings, testimony and rulings. Because this matters. It's about more than headlines. It's about the kind of society we want to live in. If you found this helpful, please like, subscribe and hit the notification bell. Drop a comment. Which aspect of this case do you think is most important? What worries you most about the challenges ahead? Thanks for being part of the Sussex Unfiltered community. Until next time, keep questioning, keep digging, and keep demanding the truth.